Good morning, everyone. I see there are about more than 117 attendees, apart from the panelists. I welcome you all to this webinar. Before we start, these testing times, thousands of health workers around the world are fighting the war against the coronavirus. As a mark of solidarity and a prayer for these brave warriors, let us observe silence for just 20 seconds. Thank you. This is Thiruvengadam basic before you. I am the Honorary Director of Bangalore International Mediation, Arbitration and Conciliation Center, India's leading not-for-profit institutional area center. I welcome you all on behalf of Aboda Governors. Unfortunately, due to technical reasons, our chairman and vice chairman are not able to join this webinar, and they convey their greetings to you all. In a short span of 6 years, BIMACC has gained the respect and confidence of disputants around the world, as well as the area centers and users. The topic of this webinar is relevant. There are many programs being organized by many. I am overwhelmed by the number of registrations that we have received. And I'm sure this webinar will not disappoint any one of you, as we have one of the excellent panelists one can expect, the brilliant panelists from all over various parts of the world, apart from experts within our own country. I need to, and proud to say that, I'm honored to say that we have His Lordship Justice, Mr. Vikramajit Sen, who is going to inaugurate this event and also deliver the keynote address and also participate in the first session as one of the moderators. Justice Vikramajit Sen, as most of in India will know, was a judge of the Supreme Court of India. I had the privilege of appearing before him in the High Court of Karnataka when he was the Chief Justice of the state. And he's also presently the Chairman of the Bombay Stock Exchange. And His Lordship has passed several judgments, landmark judgments. Without waiting further, I invite His Lordship Justice Vikramajit Sen to deliver the keynote address. Thereafter, I'll introduce one by one all the panelists. Lordship Justice Vikramajit Sen.
Good morning all. I hope I am audible. I speak for all the participants and of course for myself in thanking the Bangalore International Mediation, Arbitration and Conciliation Center for organizing this webinar on a very, very topical and important subject, the resolution of force majeure disputes due to the COVID-19 lockdown. My special thanks, of course, go out to Thiru. I think that's the best way to address him because his name is very long and it's a tongue twister even for Indians, and for Europeans it will be an absolute nightmare. But Thiru has appeared before me, and I always found them to be extremely thorough and what is very important for lawyers, but which is a rare commodity, to be fair and not to go to absurd lengths to espouse the cause of his client. Thank you, Thiru, for saying some nice things about me. Usually it is said that lawyers laugh with a judge when he is in court and laugh at him when they're not in court. And therefore, compliments which you receive after you got off the bench are indeed very, very welcome. I also welcome some of my erstwhile colleagues who have also joined us today. The significance of COVID-19 is well appreciated when we keep in mind that there are several governments which are threatening to sue another government for trillions of dollars. Of course, as a lawyer, the questions, it throws up manifold questions. Who will, if such an action is taken, who will adjudicate? Which forum? Will it go to arbitration? Will it go to mediation? Perhaps, of course, the right way to do it is to go for mediation first, and then, if the matter is not sorted out, probably then go for arbitration or some other remedy. And in fact, I think only mediation would succeed in a matter like this. Of course, we hear now that the origins of COVID are disputed, whether it started from one particular country and at a particular time is now sought to be diluted. And also whether it was by accident or was it intentional. If it was by accident, since we've got mostly lawyers here, the principle of Ryland versus Fletcher would come in. If you're dealing with something which is so inherently dangerous, special standards of care are required. If there is some kind of adjudication of a claim like this, I think we all realize that the balance of payments is strongly in favor of one particular country, so perhaps recovery will not be a difficult prospect. However, this is not the subject for today's discussion, but it does show that the whole world has been brought literally to its knees, and that too in all the homes. And this pandemic has occurred after 1 century. I think the earlier one, comparable one, would be the Spanish flu, where the casualties in numbers, when compared with the world population at that time, was much more threatening. We had SARS, swine flu, more recently. But this did not disrupt the world as we find it disrupted in the last 2 or 3 months. It was also not of the same magnitude. This is absolutely gone right round the world. Those pandemics were comparatively localized. So it was not of the same magnitude. And most importantly, it is not of the same duration. We don't know when the measures which have been taken by respective governments will be diluted, and therefore the duration is presently unknown. Lockdowns have also been ordered across the globe. And in India, there has been almost well-nigh total lockdown for over a month. This has been enforced by the police, and I must congratulate the population in India, which has by and large honored the lockdown. Lockdown means you stay at home, you go out only for your essential requirements, and in cases where they have found persons who are positive so far as the virus is concerned, those areas are either put on containment or even more severe inroads, what some people would say inroads into personal liberty. It did, along with the health of the citizens of every country, what has now also become very prominent is the fact that economies are facing lots of trouble. And economists around the world have made it very clear that unless economies are revived, it may be even pointless to fight the ill health which the virus has brought in. And this realization that trade and commerce is important, it is as important almost as our health, really also brings into prominence the aspect of law which we are going to discuss today, which is force majeure. I am not aware completely of the legal position in other countries, both civil law countries, as most of Europe is, and the common law countries, is the rest of the world is. I realize that there will be a large section of our participants who have just woken up actually at about 6 o'clock in the morning to be part of this this webinar. So far as India is concerned, whenever we think of force majeure, we think of two sections in the Indian Contract Act. And these are sections 32 and section 56. Section 32 deals with contingent contracts. Now, most modern drafting of contracts contains a clause dealing with force majeure. Now, if that happens, then of course disputes or consequences of a pandemic such as we are going through will be governed by that particular clause in the agreement. In that case, it becomes what we call a contingent contract. And on the happening of the contingency envisaged in that section, we will have to determine what is force majeure and what is not. Now, of course, there are downsides also to having a clause like this in a contract, because it restricts and circumscribes the ambit of force majeure. I would probably, if I were to draft a contract, I would just say, or may not even say, because force majeure will kicks in regardless of whether you have a clause in your agreement or covering it or saying that it is applicable. Regardless of the presence or the absence of a clause of that nature, force majeure will apply, I think, across all legal systems. So, if there is something if there is a clause in your contract which spells out circumstances and events which will constitute force majeure, those will come under 32, section 32 of the Indian Contract Act, which is, by the way, is almost, is over, well, close to 2 centuries old now. If they are already spelled out in a clause in the contract, section 32 will come in, and it will have to be judged from the contingency angle. If it is not so, then under the Indian Contract Act, section 56 steps in. And 56 deals, so far as we are concerned, with the impossibility of performance. And that is where force majeure has been, the relief of force majeure has been considered by the courts in India. We have not had much litigation on this subject, but section 56 has been considered by the Supreme Court in 4 or 5 cases. Satyabrata Ghosh, I won't give you anybody who wants the details can have them. Alopi Prasad and Nahiti Jute Mills. But this has all been in the background of section 56. Does it become impossible or does it not become impossible? Recently, the string of judgments came to be considered by the Supreme Court in the Energy Watchdog case, which is a 2017 decision, so fairly recent. And after adverting to all these 3 cases where the Supreme Court had gone into impossibility of performance, the court came to a conclusion that force majeure, which had been argued in that case, will not step in where events have made the performance of a contract more onerous than was expected, or where there has been a comparatively minor shift in the factual matrix. Even if it becomes more expensive to perform the contract, force majeure would not step in. In that particular case, the importer of coal into India had argued that the prices of coal, international prices, had risen, and therefore the price of electricity and the thermal electricity should be recalibrated. The court said no, the rise of price of a commodity will not come in under the cloak of force majeure to justify renegotiating the contract. More precisely was the judgment in Dhanraj, which is a 61 decision of the Honorable Supreme Court, where they specifically dealt with the expression force majeure. And they held that it is much wider than the Latin term vis major. And really, it will cover a case where it is obvious that the events are such as are beyond the control of the parties and make the performance of the contract well nigh impossible. So this is really one of the only cases which the Supreme Court had decided where this came up. More recently, very recently in fact, in the last month, there have been two decisions, one from the High Court of Mumbai and the other from the High Court of Delhi. Now for those who are not very familiar with the legal system in India, these are courts of first instance. Not all high courts have what we call original jurisdiction, but both these courts have original jurisdiction. The prayer was in Mumbai was that please restrain the encashment of letters of credit for the reason that there has been a clampdown ordered by the government in India. The court said, first of all, held that the letter of credit is a totally distinct contract, but more importantly, it took the view that the goods had already been shipped from South Korea, and therefore an injunction would not be proper. As far as Delhi is concerned, it dealt with a bank guarantee, and it was held that the clampdown would entitle one of the parties, the claimant there, the plaintiff there, to an injunction because it had been rendered in a position where it could not complete the contract. Now I don't want to go into it much detail because I don't want to take all the time, but what would have to be seen, at least in the Delhi cases, because it was a building contract and a lot remained to be done, whether there had already been a breach or already been a delay which would invite a claim for damages and which would grant it, even before the clampdown had come in. If that was so, then I would submit that force majeure ought not to come to their benefit. We must keep in mind that, as I've already underscored earlier, that contracts, whether they are domestic or they're international, have to be honored. If they are not honored, then international trade and the economies of all the countries involved is certain to be affected detrimentally. So rather than go on more, I don't know, Thiru, how far the time factor is concerned, but let me just sum up by saying that in view of the restrictions imposed by countries to curb the spread of COVID-19 and keeping international trade in view, delay in supply of raw materials, finished or non-essential or essential, should not be loosely, force majeure clauses should not be loosely applied on them. I think every court or every adjudicator who is faced with this question should look into how much and at what stage in the performance of the contract was this force majeure remedy asked for. There is a very interesting case concerning the shipment through the Suez Canal, which was shut down for some time, and the plea was that it would become extremely expensive for the shipment costs would rise so much because of having to go across the Cape that the performance would be excused. And again, it was emphasized this is not an impossibility. This only makes the contract more onerous for one of the parties. And force majeure was not permitted. So far as India is concerned, there is a government notification of February the 19th, which relates to the performance of contracts in government contracts in India, and it says that so long as in the duration of the lockdown, there will be no claim will be admissible on the grounds of delay. The government of India has also requested that various other aspects, contractual aspects such as payment of rent, filing of your tax dues, is extended for a period of 3 months. I think that was what the government envisaged would be the duration of the lockdown, and it may well be increased. So with these few comments, Thiru, if I may, I will once again thank you for organizing this webinar and thank all the participants in being here at this awkward time. In India, it's a very convenient time, but not for our friends across the globe. Thank you very much.
Thank you very much for a very, very impressive keynote address. Lordship had covered not only the various aspects of Force Majeure, Section 32 and 56, and the precedents laid out by the various courts in this country and the relevance of it. So the entire webinar has been kickstarted with such an impressive keynote address. And thank you again for spending your time amidst your very, very important schedule during this COVID time. Lordship is in cross-border international arbitration, and he has taken specific time out to participate and address this great congregation here. Now that with the end of the keynote address, we'd like to move into the next the first session, and this is deliberations on international force majeure disputes due to COVID-19. And I'd like to introduce the panelists, not only the panelists for this particular session, all the panelists. It's going to be a very brief introduction because for shorter time, the profiles of each and every panelist will be uploaded shortly after this webinar. We are going to miss Dr. Lalit Bussum, who was supposed to speak in this panel. Unfortunately, due to some inherent technical reasons, he's unable to join us, and we are going to definitely miss, and we wanted to convey a couple of important messages. That is, Dr. Lalit Bussum is the chairman of Society of Indian Law Firms, apart from being a very respected senior counsel. He is also the president of the Bar Association of India and chairman of the Chartered Institute of Arbitrators, India. He wanted me to convey that all these three bodies, the Society of Indian Law Firms, the Bar Association of India, as well as the Chartered Institute of Arbitrators of India, will extend all sort of support to the Government of India and the public at large in resolving any disputes that might arise out of COVID-19 issues. We have Mr. Meng, Chief Executive Officer of Singapore International Mediation Center. We are very honored to have you, Mr. Meng. And very briefly, he was, before becoming the CEO, he was the CEO of IBM Asia Pacific. I welcome him here. Next, we have Mr. Joost, who's a good dear friend of mine, and he is from Belgium, Brussels. He is running this organization called Dispute. He is a dispute board chair and mediator for Consent, an ADR institution in Belgium. He is a chief mediator in civil and commercial matters and social matters, and member of Governance Committee of Belgium Supply Chain Initiative. Was formerly associated with Decathlon. Thank you. I have another great friend, Mr. Lino Orrico, a very eminent lawyer from the hotbed of coronavirus in Milan, and he is an advocate and the mediator and is part of InMediazione, one of the ADR centers of Italy. I welcome you. The other eminent participant, Mr. Joost Maassen, is a mediator dialogue in Netherlands. He is a specialist in negotiation in ADR and in commercial and corporate employment matters. He is a consultant, trainer, and coach in conflict management. Welcome, Mr. Joost. Mr. Joy Apokuten is a part of KH Lim and Company. He is a mediator, notary public, advocate, and solicitor of the High Court of Malaya. He has been called to the bar as an advocate of the Supreme Court of Singapore, though he is not practicing there, but he wanted me to tell them very clearly. Welcome, Mr. Apokuten. Mr. Dhyan Chinappa, a dear friend of mine, a colleague here, is an additional advocate general, Karnataka, and a senior advocate, very impressive young lawyer. Thanks, Dhyan, for joining, and please, you're welcome here. We have one more panelist who is not joined, that is Mr. Devesh Agarwal, who is the president of the Bangalore Chamber of Industries and Commerce. He'll be joining us shortly. Mr. Bhaskar Chandran is the General Counsel of JMR Group, and he also formerly was the General Counsel for Tatas. I welcome Mr. Bhaskar. Mr. Jamshed Mistry is a very well-known lawyer. He's a part of the International Legal Alliance, and he practices in Mumbai, very well-known for his public interest litigation. Welcome, Mr. Jamshed. Mr. Raju Bhatnagar is a management consultant specializing in strategic management and leadership. Is a leadership coach. Welcome, Mr. Raju Bhatnagar. Dr. K.S. Ravichandran is a managing partner of KSR and Company Secretary. Is well-known name in the area of insolvency and insolvency and restructuring. Thanks, Mr. Ravichandran, for joining us. And Shiv Kumar is a very senior lawyer and a well-known mediator, and is a partner of Murthy and Kumar. He is also a mediator trainer. Welcome, Shiv. Professor Dr. S. Sivakumar, who is there to join us, is a professor at the Indian Law Institute. He is former member of the Law Commission of India, New Delhi. And yours truly, Thiruvengadam, is a partner of Thiru and also honorary director of Bangalore International Mediation Center. I have 40 years experience as a lawyer and 15 years as a mediator and arbitrator. So the topic of this session is deliberations on international force majeure disputes due to COVID-19, and I requested His Lordship Justice Vikramajit Sen to be the moderator. However, he asked me to do a few things which I'm honored to carry out this task. Before we set this in the beginning itself, I'd like to share certain information. There's a wide criticism about the Indian judiciary. They say it's one of the slowest judiciary in the world. But contrary to this belief, I'd like to share some information which I got from the 245th report of the Law Commission, which was published on July 2014. I just cut out one set of figures for the year 2012. 4.69 million cases were filed and during the year, and 4.57 million cases were disposed of. That is, as against 4.69 million cases filed in the 2012, our judges disposed of 4.97 million cases. And the number of judges we had at the point of time is 5,831 judges. At an average, a judge was disposing 785 cases per annum. That is about 3 cases per day. This does not include several interlocutory applications, the recording of evidences, which are at an average 3 evidences per day. So it's a totally unenviable task faced by the Indian judiciary. And in addition to it, the National Legal Service Authority of India, which conducts a hybrid system of alternate dispute resolution called Lok Adalat. There are what's called permanent and regular Lok Adalats. Let me share the statistic which I got it from the website of National Legal Service Authority. In 2019, from January to July, 1.5 million cases have been settled, and the value that was settled is about 89.1 trillion rupees, equivalent to euros 1.1 trillion. From 1987, since its inception till July 2019, 82 million cases have been settled by way of Lok Adalat at an average of 2.52 million cases per year. Friends, in these challenging times, especially with respect to India as such, once the COVID restrictions are removed, we are bound to witness a lot of litigation that's going to flow in. The concern is that we are not doubting the capability of the Indian judiciary, but to what extent they can stretch. As it is, as you pointed out, we complain of 5 million backlog cases, despite virtually handling about close to 1,000 cases a day. What more can an Indian judge do? Is a question that I ask myself and each one of you should ask yourself. And what is the remedy? How are we going to face this? With this, I set this session into motion, and there are certain questions which arises in our minds, and every country is having problem that is due to this COVID. And we are having lockdown, like India is now we are shut down for more than 30 odd days. I would like some of the panelists to discuss or explain very briefly as to what's the period of lockdown, what are the areas that they have been the most affected. Mr. Joy, can we start with Malaysia?
Thank you, Mr. Tudor. Thank you for inviting me over as part of your panelists and speakers. Let me start with the Malaysian context in which this COVID-19 pandemic has affected us. As we all know, the origins occurred in the country, in the city of Wuhan, China, and it metaphors into a great distress for many other countries subsequently. Malaysia is also one of those countries that were affected by this pandemic. So the government has come up with certain measures through a lockdown process, which we call it locally as the Movement Control Order, or MCO. There were 4 phases to this lockdown, which started on the 18th of March 2020. The first phase was for a period of 2 weeks or so, from the 18th of March to 31st of March 2020. And subsequently, the second phase was on the 1st of April 2020 to 14th of April 2020. Now, and the third phase was from the 15th of April 2020 to the 28th of April 2020. Now, just 2 days back, the Honorable Prime Minister of Malaysia had announced again that there will be a further lockdown from the 29th of April up to the 14th of May 2020. So overall, we see a period of almost 2 months or so of that lockdown. And do see benefits out of it. You see the curtailing of the spread of the virus, and you see the reduction in numbers of people who remain to be treated. So that is a progression in that context for the Malaysian public.
Thank you, Mr. George. There's another question that needs to be really thinking of asking is that the panelists is whether there's a general law of force majeure in your respective countries, or is it a special ordinance or a special law for COVID-19 as such? Mr. Joy, you can continue.
Yeah, sure. There is no specific law. I suppose my quick research showed that unlike England, which had the COVID Pandemic Act of 2020, or Singapore has its own, specifically for this pandemic, the Malaysian position is that the laws that were passed and implemented for the lockdown and various other purposes arising from this pandemic was based on the general law known as the Prevention and Control of Infectious Disease Act of 1988. So that is a law under which, rightly or wrongly, that the government had to enforce and implement so that the pandemic can be constrained. So as much as there's questionable whether the use of the law, but in reality it's a necessity.
Thank you. Thank you, Mr. Roy.
Well, there's a speaker from Singapore, but I believe in Singapore it has been extended even beyond 14th of May.
Mr. Meng?
Hi. Hi everyone, I really delight to be here. Thank you for your invitation, Tiro. Very pleased to be amongst this very an excellent panel. So as for Singapore, you're right, Justice Sen. We started what we call the circuit breaker, which is actually virtually a lockdown, starting with 7th of April, which was initially set for 4th of May, 4 weeks, where there are very significant restrictions on social distancing, restrictions on movements, closing of non-essential businesses, working from home, a whole slew of measures were put in place. This week, the Singapore government has decided, based on the progress that we have made in combating this disease, to extend that to the 1st of June. So there's an extension of another 4 weeks. So altogether, we are looking at least 8 weeks of this what we call circuit breaker, and it's been challenging working from home for the SIMC. The Singapore International Mediation Center, but we continue to operate online and having a lot of our interactions, our engagements, and even our mediation moving to an online platform. Under Singapore, we do have an act that was set up that was actually passed on 20th of April. It was COVID-19 Temporary Measures Act. It was drafted in record time, and the idea is to provide some kind of a temporary relief from legal action for parties that who are unable to perform their contractual obligations. So under this act, the COVID-19 Temporary Measures Act, there are a couple of sectors that have been targeted and focused on. Not surprisingly, it would include the construction sector, supply of contracts, non-residential leases, tourism, travel industry, and then loans, especially for small and medium-sized businesses to ensure that the assets that are attached to these loans, the security under these loans cannot be forfeited. So there's a measure of protection for certain business sectors. What the parties need to do if they want to obtain relief under this act is to apply for notification for relief. There's a website by the government that allows queries as well as for application. And if both parties agree that this temporary moratorium should apply, then the parties can proceed to have this moratorium apply to them for the next 6 months. So there is a 6-month time period, which is extendable. But if one of the parties do not agree, the other party, the counterparty does not agree, then they go before an assessor, who will then make a determination as to whether this COVID-19 temporary measure should apply to that particular transaction. Now, the government has also set up a group of assessors that, because we do expect a large number of these cases to come on board, and they have been, a lot of application has come in, so the government has also set up a group of assessors to ensure that this is not just this is addressed very quickly by this group of very experienced assessors to make that determination as to whether the COVID-19 Act applies to those particular transactions. So that's the law that's been introduced in Singapore. Thank you.
Thank you, Meng. What about the law in Netherlands, Mr. Joost? Mr. Joost Maassen, are you there? Okay. Then we'll continuing this. I'm not sure where they lost connection with Mr. Joost Maassen now. Okay. Are there any specific? Okay. This question, I think I should, from the Indian perspective, I want from Mr. Bhaskar Chandran. Is there, what steps, according to you, the government has taken to minimize the financial loss to citizens and business enterprises? Let's start with India. Mr. Bhaskar?
Hi, Thiru, and morning everyone. And Thiru, thanks for having me on this panel. Thiru, this is as everybody knows that this is a global pandemic, and no one knows for sure how this is going to unfold. As Lordship said at the beginning, the magnitude of this impact, it's extremely hard to predict. And while some experts have drawn some assumptions and conclusions, they say that this could potentially, we should come back to the pre-COVID period, anywhere between 12 to 18 months, but that's subject to various assumptions and so in this backdrop, where we are looking at, we are in a lockdown period, and then the post-lockdown. In my view, the Indian government has done exceptionally well in terms of one, combating the COVID, and also providing certain relief measures. The lockdown is lockdown in India is very difficult to implement, but they have done it very well. We are currently in the lockdown period. And if you really look at what government has done at this point in time, one, they have come back with measures during this lockdown period. They have also come back with measures post the lockdown period also, and that's more so from the point of the business enterprises and things like this. To name a few, Ministry of Corporate Affairs, they have come back, they have come out with statutory and regulatory compliances, where they have given various time period for compliances which were to happen during the lockdown period. They have extended those times. GST returns, everything has been, in terms of the compliances part of it from the enterprises, they have extended that. Ministry of Finance, they have come back with a relief measure to the tune of about $3 billion, about 1.70 lakh crores in India. And that's to provide various measures to the citizens, comprising of free health insurance to health workers, cash transfers, social security measures, and so on and so forth. Specific to, some of the specific things that have been implemented, and one is the SEBI circular, where the Securities Exchange Board of India, they've come up with various circulars, and one of it 30th March, where they came back and talked about the credit rating agencies, and where they said that any violation in meeting the credit obligations, the downgrading of the rating should not happen. And similar to that is the RBI circular. RBI came back with a circular on 27th March and 17th April. This is in particular I'm talking about the asset classification standstill. There has been a bit of sort of confusion with respect to the 27th March, whether it would only apply to during the moratorium period of the period of 1st March to 30th May. But they came back and later clarified in the 17th April that any dues which are even outstanding as of 1st March, which means that somebody is an SMA2 where there are dues for more than 60 days, and within a next 30-day period, they will go into the NPA classification. They have given the benefit to them also, avoid the 17th April circular. One more, which possibly is likely to come, is on the insolvency and bankruptcy court, where government is currently contemplating to suspend some of the sections of the IBC code, section 7, 9, basically allowing a financial or an operational creditor to initiate insolvency process. Government is contemplating to come back and then give about 6 months moratorium, for this. So, if you really look at all these things, one, Indian government has done exceptional and very fast and quick to come up with these measures. And in my view, the question remains that these measures, one, are they adequate? To begin with, yes, but to be, I think in my view, it has to be a continual process. And government has taken outstanding steps in terms of coming out of these, it would minimize the financial loss, but in my view, it has to be a continual process, and till the economy bounces back. So one has to really see after the lockdown how things are going to unfold, how the affected sectors are going to cope up with, and more measures, in my view, will certainly come. But very positive so far, and in terms of the way in which the government has reacted to this crisis. And in my view, the government will continue to stay close with the industry to work with in terms of coming out with additional and further reliefs as we move forward.
Mr. Joost, are you there? Mr. Joost?
Yes, I am.
Yeah. Welcome.
Yeah, Hanot.
Okay. Could you tell me what are the financial and legal protection measures provided to the vulnerable, unorganized labor sector comprising of casual workers and workers with 0 hours contracts in your region?
Actually, I didn't prepare for this question, but what I'm aware of is that in the Netherlands we have a very comprehensive social security system, which covers a baseline of income for most employees, even the employees concerned in your question. So I think our social security system covers a base income for most employees concerned, and also a new law has been drawn up to provide financial relief for employers with the aim of making it possible for employers to keep employees employed. Would that answer your question?
Thank you. And thank you, Mr. Bhaskar. I think we missed out on that. So thank you very much. And Continue with Mr. Bhaskar again. This is going to be a very specific question in relation to how I started this conversation, this particular session. The pandemic, which we show, resulted in a tsunami of commercial and contractual disputes. How do you think the courts are equipped to handle the domestic and international force majeure disputes? You having the perspective of both domestic and international disputes. Mr. Bhaskar?
Before I share my views, I would like to give some statistics, and I'm sure you did cover some of it in the very beginning where you talked about the Law Commission report, and in terms of the number of litigations in 2012 and to what extent, how, those have been, how many litigations have been resolved at that, in 2012. Now in India, because there are so many other foreign participants, like in India, you have the Supreme Court, and we have about 25 high courts in India, and about 675 district courts. I don't know what's the number of lower courts. I don't have the number, but I when I was going through when I was researching, I found that in Delhi alone there are about 250 lower courts in Delhi alone. You can imagine the number of courts that one would have in India, and I guess that it could be close to about 10,000 plus. I don't have a number, but it could be close to that. Another set of information which I looked up yesterday, and I looked at it, there are about 3.53 crores of cases which are pending in India at this point of time. As we speak, it's about 3.53 crores cases pending. Supreme Court alone, there are about 60,000 cases. High Courts about 45 lakhs, and balance about 3 crores in various district and lower courts and tribunals, etc. So what we are talking about at this point of time is this magnitude. It's a pre-COVID. It's not. I'm not talking about post-COVID, how things will unfold. In the pre-COVID situation, this is the magnitude. Then the question comes: is it been efficient? And before I go back and then I echo the thoughts what you mentioned before. It's fairly efficient. It's working exceptionally well. And I had the opportunity of doing some cases in the US. I had the opportunity of doing some cases in China, where I found that in China we had a case where the judgment was resolved, and the order was pronounced after a period of 1 year in the Supreme Court. So in India, it is in terms of my litigation experience in the last 30 years, it has been fairly and highly efficient in it. Now, with this backdrop, now let's look at post-COVID, how the situations are going. In my view, there are going to be multiple issues that could come, issues in respect of contractual, issues in terms of non-compliance, banks and financial institutions and the lending institutions taking corporates to NCLT. Last but not the least would be the insurance issues, insurance claims. While the contractual disputes, the first dispute resolution clause would be the arbitration, but eventually that would come to courts. And all these things would eventually end up in commercial courts, and these are all commercial, in the realm of commercial disputes, and will end up in a commercial court. I would like to now answer the question to what you asked, whether the courts are equipped to handle this. In my view, the question is not with respect to whether the courts are equipped to handle this. I think the primary thing in my view is that how do we come up with legislations, laws, circulars to minimize the disputes? For example, I talked about the RBI circular. I talked about the IBC where they only gave a moratorium. All these things, in my view, will minimize the risk, will minimize or will bring clarity to these issues, thereby, providing clarity, thereby the disputes will be, to a large extent, it would be minimized. Still, I don't say that
there will not be disputes on COVID. There will be disputes on COVID because even if there is a legislation, even if there is an RBI circular, then the applicability of that would still, people will dispute, people will question, they will come to courts. But to a large extent, this clarity, this legislations that we bring in terms of providing clarity to this COVID issue, to a large extent will minimize this. And to summarize the question that you put to me, Thiru, in my view, our court systems are fairly efficient. Even a pre-COVID, we have been able to manage in a fairly successful manner, in a fairly expeditious manner. I guess that the courts would continue to provide the judicial relief as quickly as possible.
Thank you, Bhaskar, for your valid points. I do agree, yes. The circulars, if there are no ambiguity in the circulars and the legislation or ordinances that may be promulgated shortly or in due course, as long as there's no ambiguity, there will be, and there's clarity, there will be definitely less litigation. But I do agree that we need to be prepared for cases, really floodgate of cases that are going to come in. And now, what are the views, Joost? How about your views? How is it in Brussels, in Belgium?
Yes, good morning to you. Thank you. Good morning from Belgium, everybody. Yes, we are in lockdown as well, and since the 18th of March now, it's ongoing. It includes a number of things, as it may show from my haircut. It also, or the absence of it rather, I would say, also barbershops. And just last night, the Security Council, chaired by the Prime Minister, shared some possible or conditional exit strategies with us, but we're ongoing. And so yes, there have been also a number of decrees as well as supportive measures towards which some of the speakers have referred in their countries. I'm not going to go into details for that. It's both supporting individuals as businesses. But still, with this respect, I would say that we can also expect in the very short term an avalanche of conflicts, in addition to the ones that were the usual pre-crisis disputes. There's been a genuine business disruption, and there's a lot of people without prospect or perspective ahead. So there will be an avalanche of disputes. And the force majeure concept is a familiar one in the Belgian civil code. It's often referred to also in contracts, mostly in what I would call the boilerplate text. Belgium missed out on the opportunity to do as other legal systems have done with the introduction of the theory of hardship, allowing for contracts to be renegotiated or otherwise modified in hardship circumstances. But so I would say that, as in other countries, the current laws governing the relationship between creditors and debtors in general are not well suited to this unprecedented situation we know. And no, our courts in Belgium are not sufficiently equipped to take more caseload. We are already in Europe, after Romania, we have the biggest caseload in civil and commercial cases per capita. And on average, only in first instance judgment will take 555 days. This being said, I personally don't think that history, and more judges, by the way, will award honorable prizes for filing tsunamis of unilateral force majeure cases. This is not a time for unilaterality, and so I would like to address the maybe opportunities that this holds. We can fall back on principles of good faith. I think there's really a window of opportunity for that. And I would say, without falling into the cliche of this this virus wants to tell us something, I think this may and will accelerate a shift that was already steadily underway before this crisis. A shift towards ADR, not purely of ADR as such, but I would say ADR within a bigger picture shift of sustainable transformation. I'm an economist, and as an economist, I can generally observe that there is a sustainable development transformation at this moment going on. It's becoming more and more mainstream. I'm observing how businesses are moving away from what I would call self-oriented, own interests first, own shareholder value, privacy, the old Milton Friedman doctrine, to a much broader stakeholder value perspective. Even in the US, I would say a country where we could go divided by what is perhaps a current transient populist uprising against such a transition. But just before the crisis, the Business Roundtable, which is a roundtable composed by 180 of the biggest corporations that periodically issue the principles of corporate governance, they have formally introduced and included a commitment to all stakeholders in their charter. And so one could even argue that this is something that is becoming now legally binding. It's becoming a social responsibility, and with regards to ADR, the signing of the Singapore Convention, but also our latest Belgian law on ADR. We might talk about that in a later session. Session 3 is more a specific illustration of sustainable transformation being more and more institutionalized. So it's probably, I think, a much longer journey we've been on than this crisis. This crisis is just another nudge towards that, although it's, of course, I would agree, also an acid test. Behaving properly in market conditions and market systems, and when managing conflicts of interest, integrating humanity, ethics, treating people well in business relations, all that is not new. We owe a lot to, with respect or with credit to the part of the world you're in, already in, for instance, Hindu scripts like the Upanishads, that were later picked up by Western philosophers like Schopenhauer. These things, they occurred. So I'm hopeful. I'm even optimistic that the current situation will have us reflect on what is a natural strategic approach to this, and that is approach that is called collaboration and cooperation, rather than competition and litigation. And I think that regardless of culture and political views or resources at hand and culture and so on, mediation can and will play a positive role now. So that is my view on that. Thank you.
Thank you, Joost. I think you're fairly apt and right in saying that ADR is going to play a very, very important role, and the development of ADR is going to be significant to handle these sort of COVID situations. And I do agree, yes, it's not just litigation or having a conflict. It's a question of understanding and trying to mutually resolve through negotiations or through intermediaries like mediation. Thank you very much for your input. Now, Lino, are you there? Now, we do share a lot of commonalities between India and Italy as far as litigations are concerned. That's what people do say, that we have also seen in the past that there's a very bit of litigation in Italy. So what are your views on that?
Please, the audio quality was not great. Could you repeat the question, please?
Yeah. No, I want to know what are your views on the issue as to how your courts are capable of handling these sort of issues of COVID-related disputes, knowing historically that you have people in Italy say that they are compare themselves to India as to quite a bit of backlog of cases in both the countries.
Okay, thank you. Hi everybody, from Milano. That, as many of you know, is almost the center of China of coronavirus, but everything is going well. It's a sunny day. It's early in the morning, and that's great. So, about the emergency of COVID, reflecting on the cause. First of all, we had a decree that all the trials, civil and criminal trials, were suspended effective March 9th, and they will be suspended till May 11th. Unless there are urgent cases, and in that cases, the courts are managing online hearings. And the Ministry of Justice is using a platform that is very easy to use, that is Microsoft Teams. And it works well. I had a hearing last week of about a labor case, and me, the lawyer, and the judge were connected by this platform, Microsoft Teams. I'm sure that there will be a reflection of coronavirus pandemic on the processes. First of all, because of the suspension of 2 weeks. Most part of the hearings were delayed to October, September and October. So if we have an average duration of a process of about 1 year and a half or 2 years, of course, for the future they will last longer. And the main problem is that also the offices of the courts, they have to take countermeasures in the future in order to manage the security of the workers. So for sure there will be emergency also about processes in the next future. And mainly for us, for lawyers, as all the processes are suspended since almost 2 months, of course there is a reflection of our work, a negative reflection.
Lino, just to add on, is there any system where mediation is mandatory in Italy, or is there any proposal to make it mandatory? Pre-litigation mediation, I should say. Is it mandatory?
Mediation is already mandatory since 2010 in Italy. About coronavirus emergency, I think that the reflection will be mainly on rent contracts, because there is a premise to do, and it is that mediation is not mandatory for all the cases. And they are discussing to extend the mandatory of the mediation to all the cases, because as it is easy to foresee, force majeure will be the main issue of the future of the processes, as in common law countries or civil code countries like ours. And I'm sure, as I can confirm it because of the experience of the last 10 years, that mediation is a very effective instrument to avoid delays of the processes and to have more effective solution of the controversies. So I think that is something that is already effective in Italy. So from that point of view, we have not to work to there, with the exception of extending the subject matters of mediation to all the cases.
I'm glad that there is a sort of mediation is mandatory in Italy to an extent. Thank you, Lino. Can I have an opinion from our friend Mr. Meng from Singapore? Do you think making pre-litigation mediation mandatory would help to resolve especially COVID-related issues? Though this should actually come in the third panel, but I thought it's quite important to get the international perspective here also. Mr. Meng?
Hi, Tiro. That's actually a really important question, because as all the panelists were talking about how we'll be facing an onslaught, an avalanche of potential lawsuits right after the lockdown is removed. I come from a background of facilitative mediation, where we believe that in order for mediation to be really effective, you need both parties to buy into it, to really commit to it, and to make it mandatory might affect that aspect of having the parties to volunteer. So I'm in a little bit of a struggle here. I do see the benefits of making it mandatory, because it would then help to reduce the expected load of litigation cases, arbitration cases. But at the same time, it sometimes goes against the grain of the whole idea of mediation being party-led, being party autonomy. So I think maybe some kind of a compromise can be met. I would say that from our perspective, we do encourage parties to mediate, both on as far as the courts are concerned, and in the family courts they are mandatory, but other than the family courts, the rest of them are really volunteer, heavily encouraged. So perhaps some measures can be put in place instead of making it mandatory. Perhaps there can be some kind of penalty that might be involved if the parties refuse to mediate. And I would think that at the end of the day, for mediation to be successful, to be long-term, to be enduring, to really help the parties salvage the relationship, you do need them to have complete buy-in in order for it to be to provide the best solution for all parties. So that's where I sit. Thank you.
Thank you, Vivek. I do share your sentiments of that mediation process has to be voluntary. But at certain circumstances in India, what we do is a little bit of nudge is required to make the parties at least come to the mediation center. It's up to them to show their face or walk out. Anyway, what are the views in Netherlands in mediation being mandatory, pre-litigation mediation being made mandatory in Netherlands, Mr. Joost?
Yes, in the Netherlands we take the Singapore line, if I may call it that. Mediation needs to be voluntary for the parties to commit to it. There has been a law drawn up which prompted parties to endeavor mediation prior to being led into court, but that law hasn't made it yet. On the other hand, I do see mediation is on the rise in the Netherlands, not just in family cases, but in commercial cases as well. And I do expect that mediation, which is actually conducted negotiation, so force majeure cases actually are cases that require renegotiating the contract. And I do think mediation is a very valuable instrument for that. And I expect not just a tsunami of court cases, but hopefully also a tsunami of mediation cases, which will allow us mediators to help society in general to overcome this crisis.
Ms. Joost, what are your views about mediation being made mandatory in Belgium?
Yes, thanks, Vito. Well, I pretty much share the views of the distinguished speaker from Singapore, although I think that nudging sometimes can help to regain something that was a historical backlog or something like that. Now, in Belgium, we have a new law since 2018, it's the summer of 2018, which I would call something like a soft opt-out system, which so parties have to justify why they wouldn't be in amicable talks or would not like to mediate, and then a court can now order mediation unless both parties oppose to that. So if only one party agrees on that, a court can order mediation. But it is, of course, an opt-out. Now, with regards to COVID, there hasn't been anything that has made mediation or whatever mandatory in this period, although there have been a number of initiatives that are very interesting. For instance, at the initiative of someone that you know very well, also Theo, the initiative of Gerard Keuken, who's the chair of Mediation, but who's also on the board of the Brussels Chamber of Commerce. There has been a pool constituted of voluntary mediators that at this moment help companies on a voluntary basis pro bono and I'm on the pool as well, to renegotiate the current contracts. So nothing is mandatory, but it's very helpful, and there's also demand for it by companies that are confronted, and that is something that they will, of course, occur to pre-litigation. Does that answer your question?
Thank you, George. And Mr. Joy, do you have anything to say about this?
Yeah, thank you, Mr. Tiro. I heard what the other speakers have mentioned. I subscribe to what they say. Just to add to this, one was Ben, and I'm just going back to the earlier question about the tsunami of cases coming up to the court. Let's not forget, with this current lockdown, we also got the backlog of cases that's taking place. So that with the additional cases coming in, the courts are going to be inundated with lots of cases as well. So that's going to be the first problem which we see that happening immediately after the lockdown. Now, the way forward, as far as I see it, is that we need to curtail this litigation. Mr. Busker correctly pointed out that if we have the measures by the government, stimulus packages or whatever term we want to call it, that will help companies to revive their businesses through finances, loans, and so forth. That could alleviate some of the problems that we go through to litigation. But that's not only the situation that we are envisaging. There's others as well that may occur, where parties will still go to court to have the matters disputed. Now, there is to say that mediation is voluntary, I agree, but we are in great situation in which it's unprecedented. We need to take drastic steps. We need to take drastic action so that we can prevent overrunning, for want of better words, the court system. So making mandatory mediation is one way forward, which means parties will have to come and resolve that dispute. If they can't, then that's the next level to go to court and get it adjudicated. Now, mediation process may not just be between a court-sanctioned mediation. The parties can actually avail themselves of that process through the various centers that's available. Now, doing it apart from mediation, just giving an example, in Malaysia, for instance, they've just passed some laws with respect to winding up proceedings in terms of the parties' debtor's inability to pay its debt from a period of 21 days to 6 months, and the increase of the inability to debt from Malaysian ringgit 10,000 to 50,000. Now, these are measures that have been taken by the government, but may not seem fair to the creditor. Now, in lieu of doing this, they probably have a mediation clause where both the creditor and debtor meets a mediator and try to see to amicable resolution to the dispute, i.e. whether there should be variation of terms or variation of the contract or longer periods of repayment. That's one of the options which a mediation process can assist the parties. Now, the other thing we're also looking at is if the parties still insist on going to the court and courts are inundated with cases, we have a process in which we can have post-arbitration. Taking it from the court process with the parties' consent and allowing individuals, whether it be arbitrators or so forth, or qualified or otherwise, in that field or in that sphere, to be able to arbitrate on this dispute and come to an adjudication of the matter. In Malaysia, we have this concept by our Justice Hamid Sultan, who came up with this arbitration, University Come Arbitration Court Annex Arbitration process. It's on this website, in which he advocates this process in which parties can actually, by consent, perform when they're in court, refer the matter to an arbitrator, which could be within the court's premises, and could be somebody who can adjudicate the matter. For instance, a very senior lecturer in the university, a person with special field or special ability to understand the nature of the case, and to determine the matter on the basis of some rules which are his profit and his concept. So there is a possibility, and one issue is the issue of cost, which could be minimized. I think that's the constraint which the parties always have when you want to go through the arbitration process. So if we can work out on those post-arbitration matters, that will alleviate the concerns of the court having to adjudicate the matters when we are inundated with cases at this current moment. But, the concept, I think you can look at it if you want to. It's at www.janap.com. Right? That's one of the possibilities you can look at. Right? Thank you.
Thank you, Mr. Joy. Justice Sen, do you have any views or anything to comment about this particular session and general reviews about this session, please? Justice Sen? Well, we are not having a link with Justice Sen right moment. Okay. To the panelists, some of the questions have been, the attendees have asked certain questions, and if you can, you can answer, try to answer if it's possible, otherwise we can give a general answer at a later stage. There are a few more questions which we thought we should ask, but we'll be posing those are relevant to mediation as such. So I want to defer this to the third session, and if, because those are all very interesting with respect to the Singapore Convention and then the Bricken Road, the Belgian Road initiative, and so on. There are many challenges that mediation will also face. So, with your permission, I may defer some of these questions to the last session. Do you have Mr. Justice Vikramajit Sen back, please? Well, he's not around, I think. Is there any other participant panelists would like to share some of the points?
Hi, this is Jamshed Mistry here. Can you hear me?
I can hear you, please.
Yes. I think one very important aspect, even internationally and even here, the question of backlog, and now that we are moving, very quickly and swiftly, and I think rightly so, towards, the issue of virtual courts. I think in several other countries, you have a much better system of virtual courts, and maybe a lot of these disputes, including arbitration and mediation. Okay, if the physical meeting is not possible, you can immediately have that transferred online and proceed with it. So, instead of waiting for disputes to arise at that point of time subsequently and see, whether parties actually go to court, maybe this might be a right time to, facilitate a mediation, virtually. I mean, that's something that I thought I'd share.
I fully agree with you, Mr. Mistry, that one method that the courts can adopt is virtual courts, where apart from the regular court timings, they can do work substantially offline, that is off the court hours and at their own leisure, and even think of not having a live court hearing where people can even send voice messages as part of our arguments as voice messages and so on and so forth. I think the courts in India should start developing this. We have made a beginning in Karnataka to an extent. Yes, we have video conferencing in the subordinate courts, and especially in the communal side where the trials are conducted without the convicts or the under trials being brought to the courts. So most of the evidences are done used by video conference for several years. I do agree it's going to be very, very efficient and time consuming, time saving rather. Yeah. The panelists, are you willing to answer some of the questions posed by the parties? You can see the Q&A in the side. We will try to answer some of the questions, a few of the questions that have come in, because we are not going to sit and discuss whether a particular situation would give rise to invocation of force majeure or not, because the entire thing depends upon analysis of the entire case and giving an opinion. In generality, there are certain questions which we'd like to definitely answer. So one has been posed by Mr. B.V.N. Rao. Okay. He says, in a recent media noting referring to Mr. Abhishek Singh, it was mentioned that it is very difficult to enforce force majeure in the present COVID situation on commercial arrangements as well as contracts. So my answer is that whether it's difficult or not is going to be a subject matter of a litigation or a trial. That's where we foresee quite a bit of disputes that's going to come to the courts. And if people do not agree that what Mr. Abhishek Singh says is can you enforce it or not? Well, it's a situation where I call it as, it's not a win-win situation, it's a no-loss situation for one and a loss situation for another. So if I succeed in a COVID enforcement thing, that I may not win anything, but I may not lose, but definitely the other person is going to lose. So there's going to be quite a bit of litigation that's going to come in, sir. Who's that? Is any of the panelists willing to answer some of the questions posed by the attendees?
There was one question where somebody has asked that will virtual courts be contrary to the issue of the open court system, and I think I'd like to answer that straight away. And if one looks at what the systems that are available, especially in the West and in other countries as well, I think yes, even the question of cross-examination, etc., provisions are taken care of to ensure that the witness, for example, is not tutored and everything is done in a particular way, the way in which the cameras are positioned. All those issues have been taken care of in systems, outside our country. So I don't think we need to be worried about that at all. In fact, I think it will be great because we've never had our court proceedings recorded, and nor have we had transcriptions for several years. So I think it's a process. It will take its time, but I think we are absolutely in the right direction.
Thank you. Let's try to answer one more question. Before that, I got a message from Justice Vikramajit Sen. He's having difficulty in coming back online. And to answer some of the questions, he has sent this message. His Lordship refers to, draws the attention to Section 89 of CPC, which empowers the court, even in pending litigation, to refer the parties to mediation or arbitration. In addition to it, we have Section 12A of the Commercial Courts Act in India, which makes pre-litigation mediation mandatory. So for commercial disputes where you have to exhaust mediation before approaching the court, but there are certain procedures. So with that, the one more question is,
Yeah.
Yeah.
Hi, this is William here. Maybe maybe I could also add a little bit to that discussion on making mediation mandatory, some further thoughts on that. I think at the end of the day, like I said, for mediation to be successful, you really need the parties' cooperation and being very open to different options and solutions. It's not just a, yes or no, I want my full claim, or I'm not going to pay anything. So you need the buy-in of both parties. But I think something that we have not mentioned enough, I feel, is really the lawyers who represent them. You need the cooperation with the court. The court will definitely be there, Theo, like you say. They will be asking the parties to come before them to encourage the parties to have mediation. But I think what is very important is also to have the law firms and lawyers representing these companies to be very much vested in that process. The role that they play is going to be so critical in ensuring the success of any mediation. So a session like that, where we talk about the kind of issues that we face, it would be very useful if we could also cascade that to the various law firms, get their buy-in, get their involvement, so that we can all walk together in this journey, the parties. So I see Bhaskar here representing very large MNCs in India, like JMR. You get law firms and lawyers, not only in India, but also across the world. You get the courts who are represented here. You get centers like BIMACC and SIMC who are represented here, mediators. I think we all need to work together to resolve this problem. Much like a lockdown. In a lockdown, everybody has certain restrictions. You have to follow certain rules. And we all cooperate and we get through this period. And I think that as far as the legal fraternity is concerned, across borders, across jurisdictions, across courts, arbitration, mediation, litigation, we need to all work together in order to help the businesses at the end of the day, because economies and national survival sometimes are at stake here. Thank you.
Thank you. Very well put, Vivek. Actually, it has to be user-centric, as lawyers or law firms or even media centers. We need to look at the users. We thank you very much. Very well said. And with this, we conclude the first session. And as far as the participants who are the attendees, they have sent certain questions which we try to answer by way of email, and if they can send the messages to us, send their email addresses to us. Thank you very much. And we move into the next session. This is going to be an India-specific one. It's titled "The Dilemma in India Regarding COVID-19 Force Majeure Disputes." So the members of the panel in the first session will still remain here, and there are certain key persons who are going to come as the key panelists as such. So we'll be focusing on them. And of course, all of the panelists are free to remain here and contribute as and when they feel it's necessary. Thank you very much. Thank all the panelists for participating. It has been a wonderful session so far. And I'm also thank on behalf of Justice Vikramajit Sen, who was unable to log in again. Maybe he'll be doing it in due course. Thank you very much. So we are into the second session. We are about 20 minutes behind schedule, but I'm sure you all had a very, very interesting first session with the views of our international panelists. The topic is dilemma regarding COVID-19, and the key participants are going to be Mr. Raju Bhatnagar, Mr. Bhaskar Chandran, Mr. Devesh Agarwal, and we have Mr. Jan Chinappa, Dr. Ravi Chandran, and Mr. Jamshed Mistry. So, to set this session in motion, let me start views about the current scenario and the sectors that have been worst affected according to you? And how do you think the Indian industries will, what time or how will they require, the Indian industry will take time to recover and due to this, from the impact of this pandemic? Mr. Raju Bhatnagar, can I have your view, please?
Thank you. Thank you, Thiru. First of all, thank you for inviting me on this panel, on this illustrious panel, and to be a part of this galaxy of legal luminaries. I am not one such. I am neither a lawyer, nor do I have a legal training and background, so I will steer clear of getting into various legal sections and try and give you an overview from a business perspective. I think to answer specifically the question that you asked, the COVID is really created, or the corona has created a situation where everyone is having to relook and change the way that they do the business. And I think from the discussion in the previous session, the general view seems to be that it is up to the regulatory authorities and various countries to create a favorable fiscal and regulatory environment to ensure that there is a strong rebound of companies and the economy once this pandemic subsides, which is open-ended at the moment. And there are incentives for businesses, clarity in terms of legislations and laws, like Mr. Bhaskar mentioned, which need to be further focused so that there is an ability to develop innovative solutions for a sustainable and resilient set of businesses to emerge. Getting specific, my assessment is that the GDP in India will take a hit of about 4%, 4 to 4.5%, 5% maybe, for at least a year, if not two. And there is talk about incentives for import substitution from China, which are directly linked to verifiable reduction of imports. There is talk about that. How that gets operationalized is to be seen. Specifically, when one looks at sectors, post-COVID, my view is that there would be a reluctance of employees to come and work from office, especially in the services sector. The driving force for that would be closed air-conditioned spaces, proximal seating, which for at least the foreseeable future is likely to create a significant level of discomfort. Large companies, especially in the IT sector, TCS, for example, has already gone public and stated that to achieve 100% productivity, they don't expect more than 25% of their employees to be sitting in the office. Specifically looking at sectors which will have a positive or a negative impact, my assessment is that IT, hardware, cybersecurity are areas where there should be a significant uptick. Infrastructure driven by government spending should see a significant uptick. Rural rural focus is something that the government is going to focus on to generate employment, and that I think over the next year or so should see an uptick. On the negative side, I see hospitality, airlines taking a significant hit. Oil industry, for example, in the medium term is likely to take a significant hit. Currently, it is pretty much in uncharted territory. A couple of days ago, May futures in oil quoted below zero, and I don't think that's ever happened in the history of the market. So that's something which can really upset the apple cart. Real estate on the commercial side is likely to take a hit. So overall, my take is that even when COVID subsides, the resetting of balance and coming back to equilibrium is likely to take at least 12 to 18 months, if not 24 months. Thank you, Thiru.
Thank you, Mr. Raju Bhatnagar. Bhaskar, can I have your views on this, please? You did elaborate quite a bit on the policies of the government for regarding COVID-related issues. But industry specific, what is the impact? Can you please explain?
I think Mr. Bhatnagar had covered large parts of it, and that he also talked about work from home, the social distancing, and how that's going to impact, in addition to the business losses and interruptions as well. And as we all struggle to understand that this is some of the strongest economies around the globe are struggling to cope up with this, and India is no exception. It has taken a huge hit in India as well. And I read somewhere recently that the global rating agency has slashed the GDP projection for India for FY 2021 to 0.8%. So it's going to hugely impact. There is no doubt. I think everybody understands that. I thought, when I was looking at this and then, through my research and my reading, I really found that probably 5 sectors would probably be the worst affected. I'm going to name them, not necessarily. I'm putting it in the same order, but to me, I think MSME would be the worst affected as well. MSME are they are the backbone of India. Most of the manufacturing and export activities they carry, it's through the MSME, and no wonder the government is planning to. They've got a relief package of about 20,000 crores to the MSME sector, and I think MSME is one of the sectors that's going to be worst affected. And as Bhatnagar talked about, tourism and hospitality sectors, and following that is the aviation. Tourism and hospitality, as per one of the KPMG reports, they are set to lose about 3.8 crore jobs in India. And so that's a figure that we are talking about. And in terms of airlines and airports, where we as a group, we are a part of it. And we have been told that it's going to wipe out about 2/5 of the passenger traffic. It's going to wipe out, and from a total $172 billion generation, it could probably reduce to probably about 1/3 or slightly more than 1/3. And so that's the impact that we are looking at in terms of tourism and hospitality and aviation. And 2 more sectors in my view. One would be the automobile sector. Automobile sector would also be the worst affected. And factories have stopped the production activity has virtually it's stopped, and this would also impact the MSME as well, who are producing the byproducts of it, who are producing the automobile sector. And last but not the least is the real estate, and that's another sector which is going to get affected. It's going to get affected in 2 ways. One, the purchasing power of individual will come down, and therefore this will affect the pricing. Second aspect is that where the constructions have stopped, how it's going to start again. Like even after the people, there are some relief measures, and construction is opened up in a small way. But whether the workers are going to come, are they going to come back, and then what sort of social measures that's going to be provided to them, and how they are from a health standpoint, and so on and so forth. So just to summarize, these 5 industries in my view will be the worst affected. And to begin with, MSME, tourism, aviation, manufacturing, automobile, and then the last one is the real estate.
Thank you, Bhaskar, for a fairly well illustrated description of the sectors that are going to be affected. I do agree, I do endorse. One of the worst affected is going to be MSMEs, and 1/3 of India's GDP is contributed by MSMEs, and the past 4-5 years is that their growth value has come down by nearly 12%, that is nearly by 8%, that is from 15% slump to about 7%. And this is going to have a very, very serious impact. I'm sure the steps taken by the government would really boost this sector too, and so also all other sectors. Thank you very much. And now coming to our friend, Mr. Dhyan Chinappa, I'm going to have few sets of questions that I'm going to pose to you. And there's also one of the questions has been raised by and asked by the attendee. Can force majeure be invoked even after the contract does not expressly provide for, if there's no force majeure clause? And to what extent the doctrine of frustration would apply? You can explain a little bit and then say how can it work in India as such.
Thank you, Theo. I hope you can hear me now and possibly see me.
Yeah, clearly.
Okay.
let me actually deal with this issue in two portions. The first is where there is no clause and the intention of a party is to actually avoid the contract. That is the first part of it. And the second part of it is where a party wants to delay performance owing to this event of force majeure. Now, as we know, force majeure is a contractual mechanism to either avoid or to delay performance. And frustration is a legal effect of what happens when a contract necessarily need not be performed anymore. To do this, of course, we look at, in the Indian context, Section 56 of the Contract Act. Section 56 of the Contract Act gives a right to a party to avoid a contract where, because of circumstances after the contract has come into force, it is impossible to perform the contract in the same manner. The law in India, as I understand, and has been held in Satyavrata Ghosh, is that if there is a force majeure clause in the contract, then Section 56 has no application. We are now, of course, dealing with a situation where there is no provision for force majeure. Let us deal with it in two parts. The first part is where a party wants to now avoid the contract and says, because of COVID-19, he is incapable of performing that particular contract. In that event, the absence of a force majeure clause will result in a situation where a party must look at Section 56 of the Contract Act to seek discharge or avoidance of his obligations under the contract. Now that becomes extremely difficult, and the law in India has been to view such actions to avoid a contract as merely practically physical impossibility to perform a particular contract. And the interpretation has always been strict, even if you take judgments from Satyavrata Ghosh in the 50s to Alopi Parshad. In Alopi Parshad, the Supreme Court held that even if it is a change of events which has increased prices significantly, that does not give you a right to avoid performance of a contract. To a later judgment of the Supreme Court very recently of Justice Lino in Energy Watchdog, where he had analyzed the entire law and found out as to how force majeure clauses must be interpreted. Now comes to the second part of it. The second part of it is where you must delay performance, and that it is almost impossible for you to delay perform the contract in the form in which it is agreed because of, let us say, COVID-19 in this particular case, where it is not just COVID-19 but also various governmental actions which have resulted in the lockdown, and therefore a possible argument that there is a change in law and therefore the party can't perform. It doesn't know to avoid the performance of a contract. It may or not, depends on the facts, but typically you would look at a scenario where you can delay the performance. In delaying the performance, according to me, existence of a force majeure clause is not really required. Let me give you this by virtue of an example. Take a construction contract. You really can't do any construction activities right now. Or a road building contract where you can't do the construction of the road. What are the consequences of it? The consequences of it are that the employer may say, I will terminate the contract because you didn't perform. Or second, I will impose liquidated damages or claim damages from you for non-performance. That is the only practical consequence of a party not performing it. What is the justification in those circumstances? The justification is that I am in no position to perform because of various circumstances. Therefore, these circumstances act as justification for non-performance. Therefore, when there is non-performance which can be justified, which is not breach owing to a willful act or a negligent act, then, in my opinion, existence of a force majeure clause will make little difference to performance of a contract, because performance of a contract has to be assessed on the basis of whether the party is physically capable of performing, and that supervening circumstances like COVID-19 has not prevented him from performing. Therefore, in issues of avoidance, the principles will be different. In issues of delaying performance, issues will be different. And when you look at avoidance in the absence of a force majeure clause, you must come within the four corners of Section 56 of the Indian Contract Act. And that, as I pointed out, is an extremely strict approach. And that strict approach, we do not know, given these monumental changes which have now occurred, these circumstances which were never anticipated, and possibly even if there were force majeure clauses, those force majeure clauses may not have even contained scenarios of this kind of a pandemic or an epidemic. Well, it all boils down to ultimately the facts of the particular case, but I think overall this is generally the principle. Thanks.
Thanks, Dion. May I also ask, as an add-on, now what is the trend is that notices are sent invoking force majeure by way of email. There are many people who are concerned as to the legal effect of an email communication, email notice of thing. Can you just very briefly clarify your views or give your views on it?
Well, email communications today are only accepted as a effective means of communication. As we all know, even notices sent by lawyers are many times communicated by email. The Information Technology Act in India permits of communication by email. There is, of course, in certain cases a requirement of a digital signature, which our Karnataka High Court has held not be as mandatory as the law otherwise provides. But however, an email communication, given the present circumstances, would act. I'm also talking of a scenario where many contracts will find the clause that communication has to be sent by registered post or by courier. It has to be signed by a particular party. The requirement of signing, of course, is contained in the Information Technology Act as a digital signature. But if you're not examining a digital signature, but you're looking at an email, and there is no doubt that the email has emanated from a proper source, then those communications which deal with intimation of existence of a force majeure, according to me, will act as much as a notice of force majeure as possibly by sending it.
Thank you, Dion. Thanks a lot for clarifying. Now, the other issue which really worries many people is insolvency proceedings. No doubt the application of the insolvency and bankruptcy code has been suspended, but sooner or later there are going to be a lot of issues that's going to be relevant. And what I views on this, I think this should be made, and I request Dr. Ravichandran to express his views on this.
Good afternoon to everyone, and we are in an unprecedented situation, so much so that the Indian government is thinking about suspending the triggering of insolvency proceedings. I think they are going to come out with an ordinance to suspend the proceedings under 7, Section 9 and Section 10. Corporate insolvency resolution process may be put on hold is the situation today, and back to reality in the geographies where we are practicing. We are completely aware of the situation in the MSME sector, and that is going to be a difficult task. And the Reserve Bank of India, if you remember, has also come with the revised framework by which they have announced on 7th June 2019 that a 30-day review period will be there for defaults, and thereafter a 180-day resolution plan period will be there, and if that doesn't work, there will be a triggering of insolvency. So now they have announced that the period between 1st March to 31st May 2020, which is a period of 3 months, there will be extension of time both for the 30-day review period where it has commenced, it has not ended, or it has not yet commenced, and similarly for these 180 days where it has commenced, it will not be continuing to run. So this is a situation in which unprecedented situation in which the insolvency may not be the right option for the creditors to enforce, for the reason that the economic scenario is uncertain. Unless the industry is highly competitive, unless the industry is highly innovative, I do not see a possible resolution, successful resolution through insolvency resolution process. Even in cases where the resolution process has been experimented and outcome has come, we have seen a lot of creditors, forget about operational creditors, financial creditors suffering huge haircuts, and therefore I do not, in my opinion, I do not think this is the right time in order to, think about post-COVID initiating insolvency proceedings. It is not the best solution for lenders, in my opinion, not to speak about operational creditors. And the government has also increased the threshold from 1 crore, 1 lakh to 1 crore. So my view is that it is not the right time post-COVID to think about insolvency resolution process unless it is a highly competitive, highly innovative field where acquirers will be there. Today you cannot have acquirers, there will be a scarcity of acquirers who would not want to put money on acquisitions. They would want to perfect their abilities to manufacture, reach full capacity. These are all my small thoughts.
Thank you. You shed so much of light on this, Mr. Ravichandran. Now, Mr. Jamshed Misri, may I ask you, how is it the balancing act between the labor and the employee and employee during this time post-COVID? How is it going to have? What sort of effect is going to have on the industry as such? How is the labor and the employee and employee relationship going to be balanced? And what are views on this? Especially you're from Bombay, and there's quite a lot of issues are coming up, I was told, in the region.
I think if we go to our labor laws, one aspect is, of course, as you know, and maybe for our foreign participants, what really, we have a division for the workman category is covered under labor laws, and the rest would be covered under general contractual law. The fact that today a workman can approach the labor and the industrial court saying that there is temporary cessation of activities and things like that. But I think everybody, what happens if he or she can't even leave his residence currently? So for the lockdown period. Now, once it is over, what might happen? Of course, I mean the trade unions will probably get involved in this, and again the question is, of course, if it is proven that is. There is absolutely no doubt, and no activity could take place, and therefore, the question of wages for this particular period of time, are they payable or not? The government has, come out with certain advisories. Interestingly, they've used the Disaster Management Act, etc., to bring these issues into, perspective. What one would have actually expected is that perhaps notifications within, the Payment of Wages Act, etc., is also something that they could have done just to ensure. Like, for example, in countries abroad, you have this system like furlough, where the government steps into the shoes of the employer, ensures that at least their salaries are protected for a period of time. That is something that they could have thought about. It would be very interesting. We've never had a situation like this before. You've had, of course, even the term lockdown is very interesting. It's not found anywhere in labor legislation. You have lockouts or layoffs, but never this term lockdown, leading to this unprecedented situation. So I think yes, several issues. The other aspect is, of course, where the employees, the employer probably and I've seen this with private companies, they are trying to talk to their employees, make them understand their situation. So I think again, a form of mediation to understand the economics of the current situation, and how both employers and employees can work together to ensure that once this difficult period is over, you can start your relations once again, and bring up the industry or the organization back to speed. Yeah, that's what I.
Thank you, Mr. Mistry. Mr. Rajapatra, do you have anything to add very briefly to what Mr. Mistry said, maybe relating to cash flow issues on the issue of regarding employer-employee issue?
Yeah, thank you, Thiru. Thiru, if I just take a step back, when we look at a dispute which surfaces as a result of force majeure, and I think earlier Bhaskar had mentioned that there is laws and legislation, instructions, circulars that are coming out which should bring clarity and therefore reduce the level of disputes. I'll actually go a step further behind, and that a dispute will possibly arise when there is a question of survival, and a company may decide to dig its heels in if it's a question of their survival, to push to enforce a force majeure and therefore try and make life easier for themselves. And something like this requires significant out-of-the-box thinking. Some we've already seen. RBI has given a 3-month moratorium which has been spoken about. But if one was to quantify that moratorium, that translates the 3-month moratorium on interest and principal obligations of loan payments translates into infusing an amount of liquidity in the market to the extent of 2.1 lakh crores. For the non-Indian participants, that 2.1 trillion rupees, or roughly $28 billion. There needs to be more out-of-the-box thinking. Say, for example, for this current financial year, if one takes the GST collection and allows companies to file their returns but use that fund for a year at some rate of interest, it could translate into an infusion of liquidity into the system of close to $160 billion. Now, if this money is available, because banks, to my mind, don't have a risk appetite to lend further, and therefore there has to be different ways to look to infusing liquidity, which hopefully should enhance possibilities of survival and therefore reduce levels of dispute. So not just labor, I think I was looking at it in a slightly broader perspective. Thank you, Thiru.
Thank you, Mr. Bhattacharya. It was very, very informative. In line with this, I also is there, Mr. Shivkumar has been quite silent. I have not asked him anything. I'm sure he'll have a lot of points that to be delivered. Shiv, if you are around, can you join us, please? Shivkumar? Mr. Shivkumar? Professor Shivkumar is not joined. I'm talking about, referring to Mr. Shivkumar, advocate, mediator. Until he joins. Bhaskar, you mentioned in the beginning about various proposals given by the Government of India and concessions regarding this. You did refer to the RBI notification on asset clarification. Can you throw more light on it, and how do you think how effective it will be, or is there any ambiguity or confusion? You did mention something of that. So can you throw a little bit information on this?
There are two aspects to this, and one is the original circular that came on the 27th of March 2020, and where it talked about, it gave the lending institutions were granted an exemption. They were granted an exemption for affecting any further downgrade on the asset classification, and that applied to those borrowers who were granted a moratorium on installments falling due during the moratorium period. The moratorium period was 1st of March to 31st May. So, it talked about any dues falling within this moratorium period, and therefore they were given this asset classification benefit is what they are given. Bit of a confusion as to what this effectively meant, because one arguments were made that where an installment had fallen due prior to the moratorium period, what happens to the the default. And what happens is that you are into different categories of asset classification. You are in default for 30 days SMA1, 60 days SMA2, and if you meet the 90-day period, then you go to the you are classified as an NPA. This was questioned. There were challenges that were made in Mumbai and Delhi High Courts, and the first of the case that happened in Delhi, where there was clarity that was brought, was Anantaraj versus Bank of India. That's on 6th April, followed by Shakuntala Educational versus Punjab and Sindh Bank on 13th April. There was also a Mumbai High Court judgment on Transcom Tri-City on 11th April, where legally they clarified to that particular aspect that even if you are in SMA2 as on 1st March, which means that you have already crossed the 30-day, but not hit then you have crossed the 60 and not hit the 90-day period, then they extended the benefit as well. This lack of sort of an understanding in the circular, RBI came with a clarification. RBI came with a clarification on 17th of April. And on 17th April, it very specifically clarified that even if you are on an SMA2, then the moratorium should apply. So what they said was that whatever be the moratorium period, that many number of days could be exempted, and then post the conclusion of the moratorium period, then one would have the ability to make the payments post that. And if you hit your 90-day, the moratorium period would not be calculated for calculation of the 90-day period. Is that useful? Is that beneficial? In my view, yes, because during the lockdown, where there are no revenues, for example, government came back and then said that toll collection should be stopped on the road projects. So there is no revenue at this point. There is no way the road companies would have had the ability to make the payments, and extended the benefit to these SMA2 companies as well. And to me, I think it's just the beginning. And as Nagar talked about, the issue is not, in my view, with respect to what specifically the relief packages that are coming during the lockdown period. During the lockdown period is one part of it. Post the lockdown period, and especially with respect to the industries that we talked about, the industries that MSME, the aviation industry in particular. And how it is going to be, it's not that things would become normal after the lockdown period. It's not going to go back. Clock is not going to get switched back to the pre-COVID right after the lockdown. These industries would suffer. They would go through the pain. They would go through maybe 12 to 18 months how they are going to crawl back into their original position. And the key aspect, the key thing is that what relief packages are going to come to. And we talked about IBC, we talked about, I guess that somewhere originally we talked about 6 months, but now I've been reading in the Economic Times therefore yesterday that they say it's probably going to be 1 year. So how such measures are going to come, how they are going to come to benefit the industry which are worst affected and worst hurt. And that's going to be key in my view.
Thank you, Bhaskar. Thank you for this detailed explanation. I do understand the concerns of the industry. Dr. Ravichandran, do you have anything to add on this particular issue on the asset clarification notification by the Reserve Bank of India?
I would like to add only a very, very small point. Definitely, as Bhaskar has very clearly put it, the moratorium is going to be a very useful thing during the lockdown. It gets extended, and the clarification of 17th April 2020 is much needed because even an asset is already under SMA, the past due calculation will get postponed by these 90 days. But my opinion is one is on the sufficiency even on the basis of COVID. Without touching upon the revival of economy immediately after the post-COVID lockdown gets lifted. My opinion is this moratorium is required to be extended for another 90 days, which will be the period on which you will be able to come back to normalcy. So I always feel that there is a requirement for a cooling off period to give a kind of legroom for the industry, particularly the MSME sector, to come back. So it requires, in my opinion, not less than 30 days to revive their strategies and look out for being able to service their loans, interest, and other things. One of the concerns is there is the circular says accrued interest, accumulated interest is payable immediately after the moratorium ends. So these concerns have to be addressed. The second is on the banking and finance sector, digitally, how this default is going to be reckoned, because today the processing of loans are totally digital, and therefore there is a lot of IT related challenges, scorecard related, bureau score related challenges, which have also to be factored. In my opinion, these two are the points I wanted to add to what Mr. Bhaskar has already added. Thank you.
Thank you very much, Dr. Ravichandran. Is there any of the panelists willing to contribute very briefly?
Yes, can I just add one aspect, and that is something which is really not covered by a lot of judgments. The indirect effect of a force majeure scenario like this. We all talk of force majeure which affects one particular contract, like for instance a construction contract where I'm unable to perform. The scenarios where you can't perform because the business is now doing badly, like for instance you can't pay your loans on time, or you can't pay lease rentals, or you can't pay your EMIs. These are scenarios which are not really tested. It becomes extremely difficult for even a court, even with the existence of a force majeure clause, to be able to demonstrate as to how you are unable to perform that particular contractual obligation. Take for instance, non-payment of a lease rental. That has nothing to do with the COVID scenario. But the scenario is that the COVID or the lockdown has affected your business, and as a consequence of which you are unable to pay your rent. Now, how courts will examine this is really something which is very difficult to understand. You can't avoid a contract because it is not impossible to perform, but at the same time, the force majeure condition makes it very difficult for you to make payment. The only thing that you can possibly look at is some form of a mechanism by which you could mediate and try and find a solution with the counterparty, so that many contracts actually provide for material adverse. But whether you can bring in force majeure as an argument, which is an indirect consequence of what has happened, will have to be tested in court. And today I don't think there's a direct answer to that question.
Thank you.
Jan, thank you very much. It was a very important point that you did raise, and it definitely is going to be subject matter of litigation and trial, and it's going to take. That's the reason we have been talking about these. As all these issues have to be tested when it comes for trial in the courts, and how are the courts going to handle it. So with this, I thank all the panelists, and we don't have much time for answering the questions, and all the panelists have covered these. Most of these questions, I'm sure, whatever been asked, been very, very well covered. So with this, once again, thank all of you, and we go on to the last session, which is of personal interest to most of us, because many of the panelists are mediators here, and so that is, should mediation and conciliation be made mandatory to resolve COVID-19 force majeure disputes? We did discuss this briefly in the first session, and I thought it should be this should be a specific topic itself. You all know I've been a litigator, and I fight when it comes to court. Jan will definitely not disagree with me on this, but nevertheless, when it comes to an opportunity for the parties to settle, nothing like this. Post-COVID-19 has caused immense hardship. That is, during COVID times, it has caused immense hardship to many people. My perception is, whenever talk, is that there's a huge cash flow issue, that what we have to get receivables they have not got, how are they going to pay their people? All these questions come in this. How are they going to pay the vendors when they themselves have not received? And due to the lockdown, the impact is so much that most of the participants, most of the parties having a dispute, do they have an opportunity to go to the courts? As Bhaskar in the previous session mentioned, that MSMEs are the largely affected sector. One of the most of the impact is felt on MSMEs, and they have a cash flow issue. How many of them can come to the courts? What is the alternate, effective or affordable dispute resolution mechanism? Is mediation is an option? And unlike arbitration, are they going to be trusted with a settlement with an award, which one of the parties is going to challenge it, because mediation is being an option where both the parties are mutually resolved to settle them. Talking about a facilitative mediation, that's, I'm sure all the panelists here agree that we support facilitative mediation. So that being the case, and so I again invite our friend from Singapore, Mr. Wei, to continue with the issue that I raised in the first session. Do we expect problems in cross-border disputes with respect to harmonization on certain legal issues, such as limitation, claim for damages, consideration, enforcement of specific performance of contractual disputes? I'm raising this question for the simple reason the Supreme Court recently said that as far as limitation in filing cases, there's an automatic extension that is being granted by the Supreme Court. So the law is being laid by the Supreme Court. Now in a cross-border situation, how it's going to create an impact. So, Winnie, can you join us please?
Hi Tim, hi, good to be back. I was enjoying the discussion on development in India, and it's been fascinating to hear that even on the issue of insolvency, the Indian government is considering maybe suspending it, and that's really being very progressive. So on the question about conflict of laws, of how we deal with cross-border disputes where you have two sets of laws, parties from two countries, and those are the kind of disputes that the Singapore International Mediation Centre was set up really to address. And we've been very fortunate to be able to manage a couple of these cases. In fact, I would say more than 80-90% of our cases are international in nature. What we found was that in a lot of these cross-border disputes, both parties are represented by eminent lawyers from their own countries. The value of the dispute is very large. The nature of the dispute is complex. And again, both parties do have quite a lot of financial capacity to go through a long-drawn litigation or arbitration. But why did they choose mediation as a solution? And I think one of the reasons, as you brought out, was there is that uncertainty on the law, sometimes as to which of the law is applicable. How do you bring that into a final award or judgment that will satisfy both sides? And sometimes for a lot of these cross-border contracts, the relationship between the parties are critical. I'll give an example of one that we came across where a Korean party and a US party having a joint venture in Vietnam. And you're talking about a very large manufacturing plant in Vietnam. So, you know, theoretically it will involve the laws of potentially three countries: Korea, South Korea, US, and Vietnam. And because the joint venture wasn't going well, the parties were considering to close down the manufacturing plants. And as you can imagine, with that, thousands and tens of thousands of jobs potentially will be lost. The economic benefits will be lost. The business for both companies will be greatly affected. And in this case, we were able to come up with, the mediator was able to come up with a solution that really satisfied both parties, which sometimes is difficult in an arbitration or in a litigation because of the way that cases are being advocated. So in this case, the parties were able to agree to a buyout at a certain price, with the parties being bought out agreeing to come back as management to support the company, and a very long-term arrangement being set out. And this was 2 years ago, and the last we checked, 2 years later, the parties are still working together. So that's the kind of very wonderful stories we hear and we see and we experience when the parties come together for mediation. And that's just one example. If you apply conflict of laws, if you apply the contractual rights, it may be hard to order the party to do a shared buyout. It may be hard to order a price, to value a price, and get the party that's been selling up the shares to come back to help this company to make it successful on a management fee. So again, a very creative solution was finalized as a result of a very experienced mediator. And we've got some really good mediators in India. We work with Camp, we work with Lino Olapalli, we work with Sriram, and these are really world-class mediators, and you would be able to, again, have that opportunity to find solutions for parties. So I hope that addressed at least part of that question. Thank you.
Thank you, Vikram. Hello, thank you. I think someone has moved there also. Okay. Thank you. It's a very, very interesting clarification, the explanation that you gave. Yes, mediation, we believe in restoring relationship or maintaining relationship. And I do agree. India, especially Bangalore, has one of the top class mediators. So, I want to know about, I'm going to pose this question to our friend Joost from Netherlands. Considering the fact is European Union is yet to be a signatory to the Singapore Convention, how do you think there can be a workable mechanism to resolve cross-border disputes impacted by COVID-19?
I think that mediation is negotiation. It's assisted negotiation, assisted by an able mediator, and it results in a renewed contract. So enforceability is an aspect that should not have to enter into disputes that are resolved by mediation. And another thought, in the Netherlands, there's a possibility to have a mediated contract made official by a civil notary, which makes it an enforceable title. So those are the two things I would suggest to clients mediating in the Netherlands. Renegotiate your contract in good faith and trust that if you have renegotiated a deal which is interesting for both parties, that you will not need enforcement. And if you do need enforcement, have your mediation agreement notarized.
May I add something to that, Joost and Tino?
Yeah, sure.
When referring to the Singapore Convention, as much as I regret that also Belgium didn't sign it, but it's also a question, I think, that we don't really need to sign it, because we already have the European Mediation Directive of 2008 that has allowed for a number of for promotion of cross-border mediation, mediation cross-border disputes, and that also enables in certain places enforceability. So, okay, the Singapore Convention, of course, I would have preferred that that the Netherlands and Belgium would be signatories of it, but I don't think it makes much of a difference at this moment.
Thank you, George. Mr. Shivkumar, can you join us? Give your views, please. Mr. Shivkumar? I think we have lost contact with Mr. Shivkumar for this time, and this basically the people, especially in India, people have not really understood what mediation is all about. The question that comes in is, okay, when parties are directly failed in the negotiation when meeting directly, what will be the role of an independent or a third-party mediator? Okay, so let us have a view of Mr. Jamshed Mistry. To what extent do you think an independent mediator could act as an effective facilitator? A view from the bar as such.
Sure. I think, every contract, this is my view, should have that particular clause. The parties should give themselves an opportunity to have, because, for example, it says arbitration and conciliation. Okay, so before that, why not have mediation as, as a dispute, alternate dispute mechanism? I have two views on this. I think generally, if you look at places like Canada, for example, they ensure that even if a matter goes, to court, before you get what is known as the trial certificate, there is a mediation process where either a judge or a lawyer of repute is actually brought in as a part of the court process to ensure that the parties understand their respective positions, and then and that is one of the reasons why the number of cases that actually go to trial are, for example, in British Columbia, they say it's down to maybe 10% of what is contemplated, and I think that makes so much sense, and I think we must have that as a process. We have, as friend from Singapore said, some world-class mediators. I think this is a very, very good system, and it must be encouraged. And there's the number of disputes that actually need to then go to court would be very, very minimal. And I think that's the way we should go, at least as far as India is concerned.
Mr. Mistry, definitely we all endorse the importance of mediation. People fail to realize. I just want to share one example. A few months ago, or maybe about a year and a half, we had a dispute. There was a dispute between a Brazilian company and an Indian company. It's about $880 million dispute, and this was going on for several months, and went for arbitration. And from arbitration, it was referred for mediation, and they came to BIMACC. You won't believe it got settled in just one day. What direct negotiation fails? Why direct negotiation fails is that there's an element of mistrust. People do not, when they sit for negotiation, they're not open, they cannot come out very well. The concept of mediation is not, apart from being voluntary, the parties have reposed trust and confidence in the mediator. They can share information which is totally confidential, cannot go out elsewhere. So this is the basic element which really helps the mediation process to be very successful. And let me share one more information. In Bangalore, there is one of the very important court annex mediation centers, Bangalore Mediation Center. At the time which has got about 70% success rate, and the average time taken for a settlement for a mediation is just 111 minutes. People will not believe, but it's a fact. It's less than 2 sessions, and that is because the immense contribution the parties, the mediators do for this process, as well as the trust and confidence reposed by the parties as well as the cooperation of the lawyers. This won't be successful. There is a question from Mr. Shivkumar, who is not able to log in again. This has been specifically addressed to Mr. Mistry. His question is, how does the principle of no work, no pay fit into the post-COVID situation? I repeat, how does the principle of no work, no pay fit into the post-COVID situation?
Yeah, I don't think the government won't be very happy to hear a no work, no pay. I think, and nor will the employee or the workman. I think again, the question is, This is whether it's an individual sort of organization, whether it's a government, whether they can come up with a policy of various industries, what exactly their financial status is, and how they can sort of defer payments maybe over a period of time. But and of course there's the compassionate aspect as well. I mean, I know companies who have turned around and said, no, as a we would like to sort of give an ex gratia immediately of a certain amount just to keep body and soul together. So I think all these issues can be brought together. People have, for example, been encouraged to sort of dive into their savings of Provident Fund, for example. That's been another area that employers are asking them to do. But I think no work, no pay for no fault of an employee or a workman would be, in my opinion, a little harsh.
Thank you. Mr. Bhatnagar, what are your views as to why people are hesitant to come for mediation, saying that direct negotiation, when they are failing direct negotiation? What are your views on it? Very briefly, please. We need to.
Sure. I think fundamentally one needs to accept the fact that most commercial arrangements are not interested in getting into dispute, and if there is a mechanism by which they can resolve it, mediation being one, it's going to be more than welcome, because the silver lining is it doesn't jeopardize business relationships. You're not taking an adversarial position. And it was mentioned earlier, I'll take another 30 seconds. It was mentioned earlier that mediation needs to be voluntary, which is fine. But I think in India, there is need for awareness to get first created in a manner that it is not just family disputes, it's also for commercial disputes. And there has to be a mechanism for that. Maybe it can be mandated. That is the view that I had. Thank you.
Thank you very much. Mr. Joost, do you have anything to add to this?
Yes, there was a question in the preparatory remarks. Question 2, I think. Yes. Why should two parties resort to mediation after failing in direct negotiations? And I think there's a point to be made that supporting negotiations by a third party, an impartial third party, helps parties go beyond the blind spots they have relating to their own interests and the interests of the other side. And even sophisticated professional negotiating parties, assisted by
professional and sophisticated advisors fall into these blind spots, is my experience as a mediator. It's very interesting to be part of a conflict while not being part of it, because you see so many more things that the parties themselves don't see and hear, and which is why private sessions are very interesting, but also in joint sessions. So I think I'd like to make a very strong argument for assisted negotiation, having the view of the impartial third party, which will help both parties find out that there may be more that's interesting for them in another deal than getting what they want based on what they are entitled to.
Thank you. Joost, do you have a question?
Yes, I'd like to add something on the fact we talked about the trust that parties do have to have in mediation before going there, of course. I can't stress enough the important or the prominent role that judges have in achieving that trust. If we look at all the jurisdictions in the world where mediation has evolved a lot or has taken a prominent role, and let's just refer to jurisdictions like, for instance, Florida and Texas in the United States, you see the very prominent role that judges have played in promoting and empowering parties with the trust that they can have in the fact that they are better equipped with the help of a mediator to solve their problem than the judges themselves. And we see, well, in the United States, we also have, for instance, this famous phrase by Sandra Day O'Connor, who was the first woman appointed judge of the Supreme Court. He said, the courts of this country should not be the places where conflict resolution starts, but it should only be the place where it ends up when all alternative methods of conflict resolution have been considered and used. Now, at this moment during this COVID times, I see also in my country, in Belgium, a lot of what I would call evangelist judges writing open letters to bar associations, writing open letters to their peers, publishing opinion articles, highlighting the fact that going to court is not really an option, also given the urgency of the moment, of course, and then it will not find a solution and so on. So I think that that the role of judges calling upon parties and their lawyers to give priority to what I would call the ordinary or the common sense, not the technical legal sense of the term solidarity, and the feeling of mutual responsibility is very important. So judges can play a very significant nudging role in achieving that trust and empowering parties with that trust.
Yeah. Thank you, Joost. Mr. Shivkumar, are you there again? We are missing you. Okay. Going back to our friend, I'm going to pose this question to my friend Dhyan Chinappa as well as to Meng. Because one is as far as the mediation is concerned and one as a lawyer is concerned. People are skeptical whether huge construction contract disputes, how can mediation work when in the question of expert witnesses or expert evidence involves the expert witness in the evidence. How does mediation work? Well, I have my view that it can definitely work, but I would like to have the view of Meng as well as Dhyan in this.
Shall I go first?
Yes.
Okay. Hi everyone. So, when it comes to construction contracts and other complex disputes, our own experience has been that there's no reason why something that is considered complex should not be mediated. In fact, sometimes very complex issues should be mediated because the issues go beyond contractual rights. I've spoken to a lawyer in Korea where he said that from his experience, there are two types of contracts that are particularly good for mediation. One are the ones that are very small because the value is small, and therefore the legal cost is very high if you arbitrate or if you litigate it. And then the other one where it's too big to fail, where both parties cannot afford to lose the case, and therefore it is actually very suitable for mediation. And I found that conversation with him extremely insightful on his part. When we talk about construction disputes, and we've done several here in SIMC as well, we've had cases where, and we did one just, I think, 2 months or 3 months ago, where there was a project in Myanmar, a French architect, contractor that is local in Myanmar, and there was a huge dispute for a project there. And because the issues are so complex, and there are so much personal interest involved, emotions involved, because it's such a long contract, that we found that the mediation was the best way to resolve that issue. And in doing so, in any mediation, you could have an expert that will come in, that will provide some opinion, like an amicus curiae or friend of the court, or in this case, friend of the mediator. So it's very flexible as to how you want to arrange it. You could have a co-mediation, two mediators, one who is an expert in construction, and the other who is really a general mediator, so that both will add value to the actual mediation itself. If you don't mind, Theo, I really want to address that question about negotiation versus mediation. The reason is because even in a litigation on arbitration and both parties try to negotiate, why is it so hard to do for them to be successful to come to an agreement compared to having the help of a mediator? And I think there are three main reasons. One is what I call rights allocation versus value creation. So as lawyers, I mean, many of us are lawyers, we went to law school, we are very good at understanding rights, contractual rights, and allocating that right. Who should get which part of those rights? It's a bundle of rights. We learned that in first year law school. How do you bundle it and parcel it out to the different parties? But we're not so good sometimes when it comes to value creation, right? So as a mediator, because you're coming in as a creative, experienced mediator, looking at it objectively, you can add value to the whole solution. So there's rights allocation versus value creation. And the second has to do with advocacy versus empathy. So that goes to the question about, a very complex case as well. As lawyers, we're very good in advocacy. We advocate our rights, the parties' rights very, very well. And as judges, we are very good at understanding the cut and trust with the both parties participate in, and we make a judgment. But when it comes to empathy, we're just not that well trained as well. So that's where the mediator will come in. The mediator will be able to understand not just the contractual issues, but the underlying interest on both sides. So advocacy versus empathy. And the last one, Devi, you touched on positioning versus transparency. So again, as lawyers, when we go into a court case and an arbitration, a negotiated position, we are very good in position ourselves, we say what the bottom line is, etc. But transparency is where, again, the mediator can, in the private sessions, understand what the issues are, where the interests are. With that transparency, help the parties to bring them closer together. So those are the three things that I think a mediator can help to provide. Not just right allocation, but value creation, not just advocacy, but empathy for both parties, not just positioning, but transparency so that we can bring the parties together. Thank you.
Thank you very much. John? Yeah.
Well, mediation works in two ways in large construction disputes, for instance. One is an ongoing mediation mechanism. That is a mediation mechanism which I think is well accepted in the Indian scenario, where you have something called a dispute adjudication board or a dispute review board, which is really a set of 3 people who are sitting all through the time when the contract is in progress. This happens in large contracts where there are a large amount of work to be done over a number of years. In these things, the presence of experts, and they're typically engineers or experts in that particular field, who are sitting on that board to try and resolve disputes within the employer and the contractor. These work very well because no one has time when the works are going on to actually start an arbitration or to do anything at that point in time. Therefore, you must consider having one set of mediation exercise which is through the period of the contract, and have an external mediation when the contract comes to an end and disputes start. The reason is when people are very involved in the contract all through the time when the contract is going on, and the person who's going to look at it independently after the contract is over and disputes have started, there's going to be a big shift in approach. And I think having a clause in contracts to deal with mediation by a third-party mediator is going to have possibly a large amount of success than having people who have been in the contract all through. But you must accept that in the Indian scenario, especially where governments are involved, mediation doesn't seem to work too well. That is because governments and the officers don't want to really build a cat in that sense, because they don't want to take a chance of agreeing to something which might, in the Indian context, put them under any risk. Therefore, one of the reasons why mediation in the government sector doesn't work very well is because people are not willing to take that chance of settling a dispute without there being an adjudication. But I think in private contractual disputes, there is a need now to try and bring in more and more of mediation to try and ensure that costs are kept low and disputes are settled, as all of us agree, on a win-win scenario. Therefore, I think mediation works very well in construction disputes. Thank you.
Thank you so much, Mr. Dhyan. I'm just stepping in case Mr. Thiru for about a minute. Mr. Appukutin, what are your views on mandatory mediation?
Sorry, can I have the question again, please?
Yeah. I wanted to know your views on mandatory mediation.
Okay. Following up on the first session just now, when I speak of mandatory mediation, I'm speaking in context of this current pandemic. Of course, the idea of mediation must be voluntary to start with, but because of the scenario we are in today, we are so unprecedented. We need to move things. We need to achieve resolutions immediately, short term, or so that businesses, activities, and in all aspects can move on. So there's a necessity for parties to be able to come to meet if they cannot resolve the matter on their own negotiation. Going through the court process not only will inundate the court with litigation, it will also be delayed. It could take time, it could be months before it can be achieved or concluded, or even years, as the case may be. So if we could have a legislation from that perspective to make it mandatory for this limited period of time, for mediation to be concluded, say within a period of a month or two from the time when the dispute has been registered, then we could see some plausible resolution to matters. Keeping money and time in perspective, hopefully there will be resolution, because at this juncture we must bear in mind this pandemic in many countries, especially Malaysia, is a total lockdown. Every business except for essential services are shut. To get them moving, to get finances moving, to get employment moving, we need to engage. There's going to be disputes, there's going to be non-acceptance of terms and so forth. So mediation is one way of getting parties to have a meeting of minds and for an amicable resolution. So those are my thoughts actually. Thank you.
Thank you, Mr. Chuan. Dr. Ravicharan, do you have anything to say about this?
Yes, I would like to refer to these provisions. There are some statutes in which compulsory mediation is a part of the statute. For example, you can see the Commercial Courts Act, Section 12A. So there is a possibility of referring the parties pre-suit mediation. This is a very interesting in the nature of commercial dispute. Therefore, resolution must be speedy. There must be expeditious disposal of cases. Therefore, the legislature has thought it fit to introduce such provisions. Even under the Companies Act, as you may be aware, I have dealt with one matter in a producer company, which is a company dealing with agricultural activities and agricultural produce. There is a specific compulsory provision for arbitration or conciliation as the mode of dispute resolution between producer companies, members, directors and the company. NCLAT agreed with my view, that is National Company Law Appellate Tribunal, and ordered parties to go for arbitration as per the compulsory arbitration conciliation provision contained in the Companies Act. Even under the Companies Act 2013, you may be aware that there is a provision 442 which has an enabling clause for parties to ask for mediation, or the forum, that is the tribunal, can also so to order parties to go for mediation. Government of India has taken steps to constitute a mediation panel under the Companies Act, with the regional director of the Ministry of Corporate Affairs of the Central Government having the panel of mediators for the purpose of resolving disputes before the company law in relation to company law, resolved through mediation, which is a pre-adjudication mediation process. In my opinion, I agree with you. In Indian system, you must have, apart from the caveats with which Section 89 is worded or Section 12A of the Commercial Courts Act is worded, there must be a way of introducing mediation, and more so, I agree with you, in post-COVID scenario, it is not advisable for contracting parties in commercial matters to rush to courts. Rather, it would be very useful to have mediation as a mode of resolution if the negotiation between the parties fail. And I don't think that there is need for a clause for this effect. They can always enter into a mediation clause immediately after that, and I believe mediation can bring wonders because of the fact that the mediators can listen to the empathy side of it. Other matters which are not matters of evidence on record, there are disputes before company law tribunals which I have seen, where it is not about the shares of the company alone, it is about the entire family which is engaged in multiple commercial enterprises as parties and shareholders. Therefore, I agree that there must be a thrust on mediation. The government can also do a little bit in order to bring about a sort of a forced mediation, because it is not new to our system, as I said about Section 89 or Commercial Courts Act or the Companies Act. Thank you.
Thank you, Mr. Ravi. It's a point well made. I do endorse and always been a champion for the cause of mediation, and I know how important it is in corporate litigation, which I've been doing also the past 30 years. Most of the matters end up in a settlement, so why not adopt mediation in the beginning? Now, the other question, I'm going to pose a question to Mr. Lino, who has not participated much in this program. I want his view on online India. The government of India in 2016 recognized online arbitration and mediation, and notified certain centers, including BIMACC and other few centers, as providers for online arbitration and mediation. But what are your views on all feasibilities according to you? Because it's very successful model which BIMACC has been using it for the past several years, which we don't call it as mediation, but we call it as conciliation for various reasons. How do you think about the difference between confidentiality mediation and confidentiality arbitration proceedings?
Thank you, dear. I think that mediation could be very suitable for India too, because I can see that online mediation is first of all an opportunity. Of course, there is something to be considered about data protection and privacy. First of all, I think the task is from the mediation center that has to grant the confidentiality and the respect of data protection of online communications and sessions. Of course, first of all, it's a choice of the platform that has to be, for instance, for us in Europe, it has to be under general data protection regulation for European Union. And I think that I'm sure that also India is something like this to be respected. The other issue, of course, is the very easy question, who's in the room? And from that point of view, I think that there is no problem if lawyers are present with the clients. But first of all the parties have to declare that no one is present in the room. And of course, if parties accept that mediation is confidential, and anything has to be can get out from the mediation room, this is the task from the parties. I think anyway that online mediation could be very suitable for cross-border mediations. Myself, I have many of them, mainly with France, and it could be much more expensive and complicated to have a session in Milan or Paris, somewhere else. It's much more easier in having a session with Microsoft Teams or Skype. And I think that moreover, India is really wider than Italy and Europe, so I think it could be a very good solution for mediations. It's also important, I think, because also the costs of mediation can decrease using online services. So I don't see it as a risk, and if we consider that now we are also having hearings before the court, online hearings, why don't you use the same way to have hearings and session in mediation?
Thank you, Lino. May I add to that?
Yeah, please.
In the Netherlands, we are currently working with online mediations and having good results with it. Initially, the feeling was that the lack of face-to-face contact would be an impediment, but to a certain degree, online mediation also has advantages. Parties tend to feel a bit more relaxed. Everybody's uncomfortable with the new process, which also levels the playing field a little bit. So we are having success with this instrument right now in the Netherlands.
Yeah, thank you very much. I do agree. People do resist change as such, and I have one reservation as far as the online mediation. When we are having a private caucus, basically the entire environment.
All the attendees and all the panelists. Wow.
I'd like to really congratulate BIMACC on this. I think it's wonderful they are able to bring together Europe and Asia, Southeast Asia, and Singapore. So thank you, and we hope that this journey will continue, and we'll continue to have more of such excellent webinars. Thank you.
Thank you. Thank you.
Thank you very much for inviting us and for this session. Thank you very much.
Welcome, Sir Rajba.
Hi, Thiru, Bhaskar here, and wonderful session, and very thanks for inviting me, and I really enjoyed participating in the sessions. Thank you.
Thanks, Bhaskar.
Thiru, it was very wonderful, enjoyed. Everything was useful and I learned a lot. Thank you very much.
Thanks a lot, Mr. Ravi.
Thank you very much to you. Thank you very much to the attendees and to the panelists, and hope that we will have again a webinar from you. Thank you very much.
Thank you, Lino.
Thank you very much, Mr. Thiru. This has really been a very interesting and educative panel. Thank you.
Thank you very much, Mr. Singh. I'd like to thank, apart from the panelists, all the attendees who have been participating with so much of interest. A lot of questions have been raised. I request all the attendees to ensure that they send emails to us, and with their questions, we'll make our best of our efforts to answer. And I appeal to all the panelists, especially the mediators and mediator centers, that this is the best opportunity for all the mediation centers in India and outside India to cooperate and collaborate, and the mediators to collaborate. This is a way we can try to promote cross-border mediation, make Singapore Convention a successful convention as such. So thank you very much. I take the opportunity to thank Justice Vikramajit Sen, who gave a very impressive keynote address, and thank my board of governors for creating this platform, and to my colleagues, young colleagues, lawyers and young mediators, and they're also my children, Mr. Manik and Mr. Ramya, for helping us to carry out this. Thanks a lot and remain safe. All the best.
All the attendees and all the panelists. Bye now.
I'd like to really congratulate BIMACC on this. I think it's wonderful they are able to bring together Europe and Asia, Southeast Asia, and Singapore. So thank you, and we hope that this journey will continue, and we'll continue to have more of such excellent webinars. Thank you.
Thank you. Thank you.
Thank you very much for inviting us and for this session. Thank you very much.
Welcome, Mr. Rajban.
Hi, Thiru, Bhaskar here. A wonderful session, and very thanks for inviting me, and I really enjoyed participating in the sessions. Thank you.
Thanks, Bhaskar.
Thiru, it was very wonderful, enjoyed. Everything was useful and I learned a lot. Thank you very much.
Thanks a lot, Mr. Ravi.
Thank you very much to the attendees and to the panelists, and hope that we will have again a webinar from you. Thank you very much.
Thank you, Lino.
Thank you very much, Mr. Thiru. This has really been a very interesting and educative panel. Thank you.
Thank you very much, Mr. Singh. I'd like to thank, apart from the panelists, all the attendees who have been participating with so much of interest. A lot of questions have been raised. I request all the attendees to ensure that they send emails to us, and with their questions, we'll make our best of our efforts to answer. And I appeal to all the panelists, especially the mediators and mediator centers, that this is the best opportunity for all the mediation centers in India and outside India to cooperate and collaborate, and the mediators to collaborate. This is a way we can try to promote cross-border mediation, make Singapore Convention a successful convention as such. So thank you very much. I take the opportunity to thank Justice Vikramajit Sen, who gave a very impressive keynote address, and thank my board of governors for creating this platform, and to my colleagues, young colleagues, lawyers and young mediators, and they're also my children, Mr. Manik and Mr. Ramya, for helping us to carry out this. Thanks a lot and remain safe. All the best.